Hello, my name is Lee Presser. This is my show. I speak frequently to very interesting people. Some of these conversations are so exciting, so intellectually stimulating, I thought others might like to listen in. This is the reason we started recording Conversation with Lee Presser.
Welcome to Conversation with Lee Presser. My guest today is Tad Armstrong. He's the founder of the ELL Clubs. ELL means earn it, learn it, or lose it. The ELL concept was established to bring an understanding of the United States Constitution to as many Americans as possible. Small groups of citizens come together monthly to study the Constitution and how the Supreme Court has interpreted it. Since Mr. Armstrong was first here in 2007, understanding the Constitution has become a hot political topic. For some, the 2010 election was about the Constitution and the founders' original intent. Today we're going to talk about the ELL Clubs and the public discussion of the U.S. Constitution. Tad Armstrong, welcome to the conversation.
Thanks, Lee.
So, how's it been going since we've seen you last?
Very well, very well. We're trying to take this national. We had our newest club formed in Fairview Heights a couple months ago, and it's up and running. And we've got about 9 clubs around the 2-county area on this side of the river, and looking to go national with it.
There was a guy whose name eludes me over in Missouri who was interested in learning about the Constitution. I said, oh, I know just the guy. Gave him your name and number. I don't know if you ever heard from him, but
had calls from all over the St. Louis area, in fact, from all over the country. We're trying to find the magic to get the club started all over the nation. And we're getting close.
Well, let's back up and let's go to the beginning. How did ELL even get thought of in the first place? That was an interesting story you told us last
It was an
time.
informal challenge at a donut shop in Edwardsville. I made a comment one day on my way to work that so many people with very good intentions knew so little about the law, in particular the Constitution, that I was just extremely frustrated with the state of our knowledge in this nation of all nations that should know about this. A local businessman challenged me to educate the public, and I took him up on it.
The public?
Yeah, the public.
Are we talking about 300 million Americans, or just like the people in the donut shop?
It started as a very informal meeting at St. John's United Methodist Church in Edwardsville. I put a flyer on the donut shop door and one at the church, and I said, let's meet once a month. I don't know how we're going to do this, but let's learn the Constitution. And 100 people showed up at the first meeting, and that dwindled a bit because it's an intense study. We read Supreme Court opinions.
Yeah.
But it dropped down to maybe about 50 or 60 regular folks. And we didn't know how long we were going to take to study the Constitution, and it wound up being 48 consecutive months to cover it all. Over 300 Supreme Court opinions are read in these clubs, and they know a little bit more about what it says. I'll give you an example, Lee. The First Amendment, Congress shall not abridge the freedom of speech.
Right.
Now, it's a great thing if people know that and know where it is, and it tells you next to nothing about the freedom of speech, because it's anything but free. It's freer than any other country I know of, but there are limitations on speech.
Fire!
And unless there's a fire, you can't do that. But we study those limitations and the interpretation of the Constitution, all aspects of the Constitution.
Well, just give us some examples of some of the things that people didn't know that they learned through these interpretations by the Supreme Court.
Oh my goodness, that's a broad question.
Yes, it is. So let's narrow it down. We'll talk about 2 areas, 3 areas. 1, freedom of speech. 2, the right to bear arms. And 3, well, we'll get to that. Just those 2 for now.
The right to bear arms is one of the most awkward worded provisions in the Constitution, of course.
Something about a well-regulated militia being necessary to a free people. The right of the people to bear arms shall not be.
You're right.
Something
and
to that
the
effect.
commas are in unusual places, and it's very awkwardly worded. And it wasn't until...
I just heard the Supreme Court Justice, oh gosh, what's his name? Souter, was just describing that very amendment.
Okay.
And was going on and on about, well, can they have like hand grenades? Can they have machine guns? Can they, you know, I mean, of course he wasn't discussing a particular case, which is why he was free to sort of speculate. But I mean, he made it plain that, you know, he felt that there could and should be limits on this freedom to bear arms.
And there are. There will be. The case law will develop that as we proceed. But no, the Supreme Court is not going to permit us to own our own nuclear suitcase bomb. I guarantee you that. Right. There's going to be limits on that are going to take years to formulate. But of course, it wasn't until fairly recently that the court actually honed in on the bare issue of whether or not people had a right to bear arms to defend themselves. And of course, they held they do in the Washington, D.C. case and then in the Chicago case.
Right.
Right.
And that was, some say that the right to bear arms was about that, defending oneself. Others say the right to bear arms has to do with protecting the citizenry from a overly aggressive political class.
To the exclusion of an individual's right to defend himself with an unarmed weapon. Well,
right.
The second group lost that fight.
Did they?
It's been determined. Oh, sure. The Supreme Court determined that individuals have the right to bear arms to defend themselves.
Ah, all right.
Not just the militia.
Right. Well, no, what I was saying was that there are people I have talked to who see the Second Amendment as their means of holding back the government when the government decides to take over. See, they see this, somehow they see their own government as being in opposition to them, and that their right to have these weapons is the way in which they can protect themselves. We've seen this in any number of movies with guys in basements that were, you know, the police are coming or the army's coming and they're defending themselves and they're screaming about, you know, this godless army and et cetera, et cetera. I mean, it has been turned into some sort of a comic situation, but I suspect that the founders were actually thinking in some respect about making if people are armed, you just can't come in and tell them what to do.
I would imagine that's the case.
Yeah. Okay, so freedom of speech. You were just saying you can't yell fire. There's a lot of things that you can say, but apparently there are this whole question now of Julian Assange and WikiLeaks. And some in the American press are saying, well, this guy has a right to reveal state secrets under freedom of the press or freedom of speech.
And those same folks will talk about the Pentagon Papers case, and I don't understand that. They must not have read it. The Pentagon Papers case, to me, doesn't stand for much of anything. What happened in that case was the New York Times wanted to publish the papers leaked about the Vietnam War.
Right, by Daniel Ellsberg.
With Ellsberg, right. And the litigation began by the government wanting an order to prohibit them from doing that. But fundamentally, it had already been leaked. It had already been published in other newspapers. The cat was out of the bag, so to speak. And the Supreme Court would not enjoin them from publishing that material. But they also said, possibly in dicta and some of the concurring opinions, but definitely made the statement, that doesn't mean the New York Times cannot be prosecuted for criminal activity after it's published. Or if somebody dies because of the publications, they are subject to criminal prosecution. Most people forget that part of it. So that is still out there. And there are some erroneous, I'll tell you one thing we learned in the Constitution clubs is a lot of misinformation out there.
That was my next area.
Well,
there's a lot of people who know, they absolutely know stuff about the Constitution that isn't in there.
On the heels of WikiLeaks' recent leak, Michael Reagan, President Reagan's son, came out with an article that he thinks that Manning and Assange ought to both be prosecuted for treason. Well, of course, anybody that has taken our courses knows for sure that you can't prosecute someone for treason that is not a citizen of the United States. Assange is not a citizen of the United States, so that's a ludicrous comment for starters. Secondly, it's interesting to note that the provision of treason in the Constitution, first of all, is the only crime defined in the Constitution. Secondly, it prohibits levying war against the United States by a citizen, which we're not talking about here.
An overt act.
Or
an overt act.
Or, yes, or adhering to those are the methods of proof, but you're right, or adhering to the enemy by giving them aid and comfort. Well, I don't think there's any question, but what Manning's leak of this information could be considered adhering and giving aid and comfort. The question is, who's the enemy? And an interesting question would develop with a charge of treason, and that would be, we have not technically declared war. There's an Iraq resolution and a resolution following 9/11 that permitted hostilities to begin, but it does not specifically declare war. And one wonders whether or not, and an enemy is not defined either anywhere. So those are issues that would come up. But treason doesn't have to be pursued to take care of these two. There are plenty of other criminal acts.
Well, yeah, but espionage, for sure.
Yeah.
I mean, the man is guilty, and I've heard discussions about. I mean, how is it that one guy could get at all this information at such a low? I mean, what was he like a?
That's the most serious question.
An E3 or
E2
or something like. I mean, he's like way down there.
I think that's the most serious question really facing us right now. How
but that's not a constitutional issue, although it is in a sense, because the whole purpose of the Constitution is to protect the state. And somebody has failed to protect the state.
Well,
and that's the
protect
executive
individuals
branch.
As well. Bill of Rights protect individuals.
Right, but I mean the whole construct of the Constitution is to create a state and protect the state. But so that and then the Bill of Rights, so that the state doesn't become overbearing to the individual. So you say you want to take this thing national.
Right.
And we've also said that the Tea Party people seem inordinately interested in the Constitution, especially in this last run-up to the 2010 elections.
Right.
Is this why you're trying to take this national, or is this as a result of the Tea Party, or?
No, it's interesting. I started this in the fall of 2004, before anyone ever heard the phrase Tea Party or any kind of a conservative movement. I was just simply frustrated that our populace is ignorant of who the framers said that we are. I mean, you think about something being un-American. One thinks of apple pie and baseball. That's not the gist of being an American. What defines us is the Constitution. And if we don't understand it, we have serious problems. So it started before all of that began. My goal is to educate the nation on how it's been interpreted, maybe sometimes how it's been misinterpreted, to all flavors, conservative and liberal alike. And I welcome everyone to these clubs. My moderators so far are all lawyers.
Let's point out, I didn't point out, you are an attorney.
I am.
Right, so you're trained in the law and therefore in the Constitution as well.
As much as any lawyer is. I mean, most lawyers when I came through had to take a course on the Constitution. It was required. Supreme Court Justice Kagan, apparently when she was at Harvard, removed that from the required list, unbelievably so. But most of the time after lawyers get through law school and pass the bar, 99.9% of them never return to a serious study of the Constitution beyond what you and I read in the newspaper and see on television.
But when I read some things in the newspaper that judges have decided, I can understand that.
Well, I tell you what, that's the eye-opener. When you read the Supreme Court opinion, you get the truth. And that's what we do in our clubs. Right. You get the majority opinion and the dissenting opinion. You get both sides of the proposition, and there's nowhere else to go for the truth. There's no spin involved. That's the historical document sitting in front of you. And it's amazing to me how much more information you get from doing this study than relying upon what you see and hear in the media.
Well, you hear a lot of things in the media. I mean, among the things you hear is the current administration, the Obama administration, is shredding the Constitution. Well, I'm not sure what that term shredding the Constitution means, but can you comment one way or other on people who might make that assertion?
I agree with them. I agree with them. I was asked to speak right after the President's inauguration at a League of Women Voters Club, and they asked me that question. Was I concerned about that? And at that time I said, let's see what happens. It's a little bit early to judge that. Mm-hmm. One of the very first things that occurred was when Governor Blagojevich named Burris to fill the vacant seat in the Senate. And if you recall, Harry Reid and the President, both, for about 3 weeks, said that would never happen. Harry said that we have rules in the Senate, that man will not be seated. It took me about 30 minutes to do the research on this, the constitutional research and the state of Illinois research, and to determine very clearly that he had to be seated. And by the end of when the media got done with that discussion 3 weeks later, he was seated, wasn't he?
Yes, he was.
And because the Senate knew that if they didn't do that, at least 5 people across the parking lot would at the Supreme Court building. Mm-hmm. So it's a little bit difficult to...
And tell people why do they have to be seated?
Well, because the provision of the Constitution, there's a provision in the, I believe it's the 17th Amendment, but the provision in the Constitution supplies the answer to that. If the state permits a sitting governor to make an appointment of a vacancy without an election, that's the rule. Mm-hmm. And we did at that time you remember there was talk about whether to have an election or not back then. And after he appointed Burris, that discussion was over. I mean, that was the end of it. Now, they could have called probably a special election in the interim, but they just chose not to because probably the short term that was left. Mm-hmm. But no, when the President had taught voting rights at the University of Chicago, is my understanding, and comes out with a statement backing Harry Reid on that comment, you have to wonder about the concern about the Constitution. Because clearly this was just required. It was absolutely required. Mm-hmm. How absurd is this? For the President or for the top member of the Senate of the United States of America to say that the Senate would decide whether or not Burris would be seated. That should have made every citizen of Illinois extraordinarily upset. Right. Whether or not they agreed with the appointment. Well, anyway, it turned out okay.
I think that where some people are confused is what is the nature of the United States? Are we a federation of states in which states have granted to the federal government certain powers? Or are we just one big nation in which the Congress makes decisions for the states?
There's
that's a two-party issue right there.
Well, exactly. And the 10th Amendment is going to be the hot topic in the next few years as it is currently. But in my estimation, you can't do this study without taking position, without finding out who you are. I have found out who I am, and I'm conservative. We welcome all philosophies to the table. But the problem is, a few months ago in Texas, there was an issue of corporal punishment. Hit the newspapers at some high school in Texas, or maybe middle school, I don't recall. The people in that community they liked the idea of corporal punishment in public school. But it hit the news, and all of a sudden, a handful of congressmen in Washington, D.C. wanted to pass a national law to prohibit that to every state in the Union. They have no business doing that. That is not a power granted to them in Article 1, Section 8 of the Constitution. And if we do not get back to interpreting this Constitution to provide limits on the national government, mm-hmm. you might as well burn it. Might as well burn it. There's 2 reasons for the Constitution. One is to set up the structure of government. The other one is to limit government. And if you stretch the Commerce Clause to such a broad conclusion that anything that moves in commerce is the subject of any legislation they want, you might as well burn it. It's over.
Well, we're taping this on December 14th of 2010, but it won't be shown until early in January. But yesterday, on the 13th, a federal judge in, I believe, in Virginia, decided that, talking about limits, that the health care bill, which was passed by Congress last year, or was it earlier? It was early this year, that they had gone beyond the limits when they told American citizens that you must have health insurance.
Right. I agree with that decision yesterday. I predicted it, in fact. I write for the St. Louis Post once a month, and I've done that for about 13 months, a conservative op-ed piece. And just about 1 year ago, when all this was being discussed, I wrote an article suggesting that if the Supreme Court ever got back to the original intent of the Commerce Clause, there then stood a likelihood that the Obamacare bill would be struck down as unconstitutional. And I was called, let's see, one of the letters to the editor the next week suggested that I was either stunningly ignorant or willfully deceitful. Turns out maybe I might have been right, huh? and there's a statement.
Well, of course, now this is one judge making one opinion, and there has been 2 other judges on similar cases in other districts that have come to the opposite conclusion. And so this case is going to go to the the Fourth Circuit, and Fourth Circuit Court of Appeals.
Right.
Then it has to work its way all the way up to the Supreme Court.
Right.
And what I don't care, and what goes all the way back to what you were saying, you know, when you read these opinions of the Supreme Court, that you basically have 5 individuals in the United States that tell us what the law is. That, to me, seems sometimes dictatorial.
Well, as somebody has to have the last say. Now, that concept of states' rights and the 10th Amendment and nullification is brewing right now, which is a different issue altogether. But that aside, somebody has to have the last say, and Justice John Marshall decided in 1803 that it was going to be the Supreme Court.
And he didn't get challenged. But if he had been challenged at that time by the guys that wrote the Constitution, then the Supreme Court might not have that power.
It's interesting. One of the justices on the court at that time suggested to John Marshall, who was the Chief Justice, that, you know what, trouble's brewing. Maybe what we ought to do, if we decide that something they do is unconstitutional, maybe we ought to send it back to Congress and give them the right to override our decision before we run out of town on a rail. Well, they decided against that. Right. History could have been changed if that had been the case. But Justice Marshall in the Ogden case, one of the early Commerce Clause cases, maybe the first one, refers to Article 1, Section 8, and he sets forth a list of things that are not included within the powers granted under the Commerce Clause, and one of them is health. Mm-hmm. So I've got some pretty strong backing on. Mm-hmm. In addition, Federalist 45, written by James Madison. This was the Federalist Papers were designed to sell the ratification.
It was a sales document
to the citizens of New York.
Right.
And they published in newspapers. Federalist 45 discussed the concept of federalism, and Madison said, "Look, the powers granted to the federal government are few and defined. Those that remain with the states are many and undefined." And I don't think that definition fits with what we see today, when Congress thinks they can do anything they want to at any time. As right. Phil Hare said, who cares about the Constitution? Well, I do.
Right. And most citizens should. Now, we have only, unfortunately, about 4 minutes left to this show. So I want to get back to, what are you trying to do with the club to go national?
Well, website, very important, if I may.
Yes.
www.ellconstitutionclubs.com. Very lengthy, ellconstitutionclubs.com. Provides many different avenues to do this. People can download lessons on the Constitution, but more importantly, there's a button called Forming Clubs Around the Nation, and it provides forms, and it tells folks how to gather together and do what we're doing in the Metro East all over the country. I've got interest right now of a potential club in Denver, Colorado, and in Florida, And if we get just a few of these springing up around the nation, I'm hoping it will just snowball. And look, if we can have 9 clubs in the Metro East area, including one at Edwardsville High School, by the way, about to complete the 4-year program. If you extrapolate that out geographically or by population, you're looking at 10 to 15,000 clubs around the nation. Now that's an impact. That would be an impact. So that's the goal. Why not?
So you want people to get in touch with you at the www.ellconstitutionclubs.com.
Absolutely. And we'll tell them how to, we'll walk them through the process.
Right. And as I recall from our last discussion, you'd created all kinds of, I mean, lengthy syllabuses.
Oh, there's over 4,000 pages.
Right. I mean, they're not going to be riding blind or having to reinvent the wheel. Basically,
no.
you have created the entire course. All they have to do is literally just take the pages and look at them.
We provide the monthly handouts to the club members, 50, 60, 70 pages a month of Supreme Court opinions with commentary. And lawyers donate their time to this. That's an amazing part about this. I was told in the beginning that I couldn't find a lawyer willing to do this, and I've proven them wrong. We've got lawyers all over this 2-county area willing to donate about $10,000 to $15,000 of their time per year to moderate these clubs, and they're having a ball, every one of them.
Have you moved over into St. Louis or
Not
St.
yet.
Louis County?
There's a lot of interest over there, but we haven't been able to put the pieces together just yet. Hopefully to do that soon.
Well, I would think that there'd be some lawyers over there who would
I've got
be interested.
I've got
in
10
that.
to 15 lawyers in this area waiting for a club to form, but we have to get the other pieces. They have to find a place and so the people, and you know, we're learning as we go. It's a trial and error proposition, but we've learned a lot in 6 years, and that's my passion.
And do your clubs, I mean, you said the very first time that you did this at the church that you had 100 to start, it whittled down to 50.
Yeah.
I mean, was it continuous at 50? And are the other 8 clubs experiencing that level of participation?
Well, the clubs that we have now range from a very, in Highland we have about 6 folks that come regularly. That's about to end. We're almost done with the 4-year program over there. We've got about 37 in Fairview Heights. So we have 30 to 40 typically in Edwardsville, and Alton has about 25, Granite City 15 to 20. A lot of things depend upon the time of year and the weather and so forth and so on. But you can, these people take this information home with them, and it has an effect far and wide.
Boy, we're going to have you back here again, and pretty soon.
Okay.
We've run clear out of time. Thank you very much for being with us today. My audience, I've been speaking with Tad Armstrong. He is the founder of the Earn It, Learn It, or Lose It program, ELL. You heard the web address to go to, www.ellconstitutionclubs.com. If you have an interest at all, I'd go there and I would take a look. And make sure that, you know, that you tell your friends about this thing. For those of you who are regulars with this program, we will see you next Monday. Thank you very much.